Welcome to Episode 2 of Albalex's IP-Aware playlist, a series of short videos discussing IP rights for the space sector. If you want to learn about compliance in the space and tech sectors in bite-sized chunks, hit subscribe and follow us to grow your knowledge and empower your business. In this episode, we're going to be talking about trademarks. A trademark is a sign that differentiates your business, product, or service offering from others. That sign could be a word like Albalex. It could be a symbol, like our logo on screen here, or it could be a tagline, or color, or design. There are different laws around the world that govern trademark registration, and some territories, like the UK, allow for common law trademark rights where you don't have to register your mark. Your use of that mark and the reputation you gain from it is enough to protect it as an unregistered trademark. But we don't want to focus on the details of what trademarks are and how you handle them. What we want to talk about is how we're seeing trademarks being used as valuable IP rights within the space sector. So let's jump in, and there's arguably no bigger, long-standing brand in space than NASA. NASA's logos, affectionately known as the meatball, which is their main graphical mark, and the worm, which is their text-only logo with all letters running together like a worm, enjoy statutory protection in the U.S., which the USPTO relies on to reject marks bearing similarity. NASA will allow others to use its marks with permission on a case-by-case basis. Their senior IP attorney said in 2021 they hadn't ever had to sue to enforce their logo rights. But that doesn't mean they don't watch, and in the U.S., they opposed a guitar pick-shaped version of their meatball logo. The applicant did not respond, and the U.S. TTAB found in NASA's favor by default. NASA have also made their presence known in the U.K. In '94, a U.K. individual applied at the U.K. IPO for a clothing brand trademark bearing a NASA logo with the tagline, "Nice and Safe Attitude," which was effectively, applicant argued, a parody of the worm. This case was heard at the time the United Kingdom's 1938 Trademark Act was being repealed by their 1994 Act, but continued under the old Act as it had already commenced, and despite strong arguments by NASA, the applicant was successful in this proceeding because NASA couldn't pass the tests of establishing its goodwill in the UK for clothing services. That case did serve as a reminder that, of course, you can only protect your mark in a class of goods or services that you're using it for, and sometimes parties forget that. So what about the private market? The private space sector is a new economy, or a refreshed economy, if you will. So too is the metaverse, an area where we will see many legal and compliance discussions as traditional laws are interpreted for world-leading technological advances. So comparing space and the metaverse is actually quite useful for us because of some unknowns as the sector grows with private interest at the heart instead of government knowledge sharing. We saw the surge in metaverse-related trademarks with the USPTO receiving just shy of 6,000 metaverse-related trademark applications in 2022 alone. So are we going to see the same for the universe? Not only do we have the space sector entities seeking to ensure trademark protection for brand asset protection, we wonder if we will start to see mainstream brands and particularly human spaceflight, space tourism operators seeking to expand their protection to outer space. There's been a hint of that already with Blue Origin. Blue Origin previously filed for trademark protection in the US for Orbital Reef. This is essentially a space real estate project to build their own space station with a business park, hotels, and shopping precincts, etc. If you haven't seen it, check out orbitalreef.com. It's like something out of a movie that is probably not too far away from being a reality. Those applications covered a multitude of classes of goods and services, but what we at Albalex found curious was their attempt to define territory by adding some defined text to each class. If we use real estate as an example, the Blue Origin applications added, quote, real estate services in space and high-altitude locations. Quite what high-altitude locations mean, I don't know. And that's exactly why we want to have these discussions. Where are we going, and how are we going to regulate the unknown in future? While brands seek to future-proof their assets, How are we future-proofing our registration and enforcement systems? Whilst Blue Origin's attempts to file are an attempt to deal with the current status of trademark law registration and enforceability at domestic levels, many commentators have been calling for various solutions to registration and enforceability of trademarks in space. This links back to what I was talking about in Episode 1, when discussing how territory and jurisdiction can apply to IP rights in space, and the need for change and advancement in our approaches and regulations. For example, insofar as trademark registration and enforcement is concerned, some commentators suggest an extension to the Madrid Protocol. Others suggest WIPO could take a bigger role, much like its UDRP domain dispute mechanisms, and essentially become a dispute body for galactic disputes. We don't know where things will go, but trademarks in the space sector are going to get really interesting as the sector grows and trademarks become another valuable IP asset. Thanks for joining us. Be sure to hit the subscribe button to catch our next episodes in this IP series and our videos on many other space and tech sector compliance topics. And if you need more information or support for your business, including e-training and events, check out our website, albalex.com.